Red means go. Well, welcome everyone to the Zoning Board of Appeals meeting of Thursday, February 12th, 2026. If we could all make sure that our phones are off, and could we all please stand for the Pledge of Allegiance?
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, Heather, I'm going to look around that pile. So you have the order of things today, so why don't we start, please?
Okay, so first off, we'll read off the correspondences received. Patrick FEDUN, 52 Main Road, Riverhead, a request to withdraw appeal number 2025-041 that was dated January 28th, 2026. Then Judy Lynn Simoncic from Forchelli, Deegan, Terrana, 1087 Old Country Road, Riverhead, change of counsel and response to a letter from Kim Judd that was dated February 3rd of 2026. Amy Loeb, PBMC Northwell Health, 1087 Old Country Road, Riverhead, additional letter requesting to reopen appeal number 2025-042 and request to speak before the zoning board. That was dated February 4th, 2026. And then another letter from Judy Lynn Simoncic, Forchelli, Deegan, Terrana, 1087 Old Country Road, Riverhead, response to letter from Amy Loeb, and that was dated February 10th of 2026. Right. So to address the requests made, we have the request to withdraw appeal number 2025-041, that's 52 Main Road in Riverhead.
Members of the zoning board, do you have a determination?
Yes. So, Mr. Chairman, with respect to appeal number 2025-041, Suffolk County Tax Map 600-84-5-13, the conclusion determination of the Zoning Board of Appeals did consider applicant's request to withdraw the application, appeal number 2025-041, and did consider effort and expenditure of time and cost for site visits, review of history of site, reviewing the criteria of the use variance, review of applicable town code, hearing and transcript, together with consideration of staff time and attendance and time of interested residents. Based upon the same, the zoning board grants the applicant request to withdraw with prejudice to reapply for such application for a use variance for this site for 2 years from the date of determination.
So moved.
Second.
Okay, Mr. Barnes,
Aye.
Mr. Porsche,
Aye.
Mr. Zaweski,
Aye.
Mr. Godzillo,
Aye.
and I vote aye. Heather?
Okay, and then the second request to reopen the hearing for appeal number 2025-042, 1087 Old Country Road in Riverhead.
Okay, Mr. Chairman, with respect to appeal number 2025-042, STM number 600-108-4-14.5, the zoning board gave careful consideration to all correspondence recited above and the arguments and asserted facts and alleged inaccuracies in the record set forth in counsel for Peconic Bay Medical Center and President of the Peconic Bay Medical Center correspondence support a determination that the zoning board will reopen the hearing. Note, the opening of the hearing and hearing date shall adhere to all procedural provisions regarding notice, publications, etc., set forth in Town Law 267-A, and Town Code shall be met for the rehearing.
So moved.
Second.
Mr.
Second.
Barnes. Mr. Barnes.
Aye.
Mr. Porsche.
Aye.
Mr. Zaweski.
Aye.
Mr. Godzillo.
Aye.
And I vote aye.
We just set a date, I guess, right?
So
Set a date.
we could do the next meeting date, which is February 26th of 2026.
I move it be adjourned till that date. Reopen that date.
Second.
26th?
Yeah.
Okay, all in favor?
Aye.
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 Thank you. So that has been
Sure.
Good evening, Mr. Chairman, members of the board. My name is Judy Simoncic. I'm with the firm of Forchelli, Deegan, Terrana, with offices at 333 Earl Ovington Boulevard in Uniondale. I'm here on behalf of Stony Brook. We are obviously very surprised that the board has voted unanimously to open up the hearing. We would ask for more time, though, if we're putting this on for February 26th. That does not give us much time. We were just substituted as counsel. I had submitted that letter in the first week in February that we were substituted as counsel for the prior attorney. So we would like more time. So if I would, at least till the next meeting, at least a month.
I'll read off the next couple
Sure.
hearing dates. I will note that our chairman is not here. So we have March 12th, March 26th, or April 9th.
What's your pleasure?
May I confer with my client for a moment? March 12th would be acceptable.
So moved.
Second.
Okay. Mr. Barnes?
Thank you.
Aye.
Bruschetta?
Aye.
Zawiski?
Aye.
Cusillo?
Aye.
And I vote aye. So you've been moved to March 12th.
And counsel for the zoning board, just to confirm, the property will need to be reposted for that date and will handle the legal notice?
Correct.
I can supply you with a poster. I'll let you know when it's ready. Okay, so with those requests out of the way, the reserved decisions, that section is no longer necessary. So we'll move right on to the public hearings. The first hearing is appeal number 2025-032, Bayview at Peconic LLC, 47 Bayside Avenue, Jamesport, Suffolk County Tax Map Number 600-93-1-4, Residence B40 zoning. Appeal of Chief Building Inspector's determination dated July 29th, 2025, which rescinded a letter of pre-existing use issued October 13th, 2022, for use as a transient rental, and this was adjourned from December 11th, 2025.
Good evening.
Hey.
Yes, we have some of the documents that had already been submitted, but copies for the board. With,
Excuse me,
Wait.
hold on.
oops, sorry.
And Pat, if you could just lower the mic a little.
Yeah, it's such a high, giants.
Can I just, before you begin, first of all, do I have your appearance, please?
Oh, I'm sorry, yes, I was waiting.
State your
Patricia
name.
Moore,
Thank you. State your name and address.
Patricia Moore, 51020 Main Road, Southfold. I'm here on behalf of Bayview at Peconic LLC, which is 47 Bayside Avenue, Jamesport.
Just to cut to the chase, if you're gonna, we've already had a hearing on this. If there's anything you want to add, by all means, let us know, but if it could be just redundant.
Well, it's not, my goal here is not to go through all of the documents that are in your records. I think you're capable of reading the record, and you don't need me to walk you through it. I do want a moment of your time to let me go through my presentation, just to recap and create a record. Last time I was here, we kind of got off a little bit, so I
You
want
could do all that
to
in a
try.
moment?
Pardon me?
You could do all that in a moment?
Probably in 2. How's that? Okay.
Go right ahead.
Thank you. I have Mr. Fisaro, who is and his sons, who are the members of the Bayview at Peconic LLC. This is a continuation of our hearing seeking confirmation what the law already recognizes, that this property's longstanding use as a single-family residence with transient rental constitutes a lawful, pre-existing non-conforming use under 301-222 of the Riverhead Town Code. This is a request for a recognition of a vested property right that has existed for more than 60 years. The use was lawfully established. The record is clear that Fisaro family purchased the property in 1962 and began using it as a single-family home with transient rentals at that time. When the town adopted its zoning in 1959, the one-family dwelling was a permitted use. Importantly, the town code defined dwelling as a structure occupied as a home either permanently or transiently. So at the time this use began in 1962, transient occupancy was expressly included within the definition of a permitted dwelling use. The use was lawful at inception. That is the first and most critical element of this case. In 1995, the town amended the definition of dwelling and removed the reference to transiently. The property had been used for transient rentals for 33 years at that point. In 96, Chapter 86 was adopted requiring rental permits, and in 2013, as you know, a prohibition was adopted, transient rentals for fewer than 29 days. But under the well-settled New York law, when zoning changes render a previously lawful use non-conforming, that use becomes a vested property right. We've given you cases to that point. The town code itself recognizes this principle in 301-222. So the law protects uses like this one. Under 301-222, abandonment requires discontinuance for 1 year or more. There has never been a 1-year cessation of the use. The applicant has submitted affidavits from the neighbors, affidavits from renters, tax records, business records, and photographs. All demonstrate continuous transient rental use dating back to 1962. The evidence here is not speculative, it is voluminous and documented. Section 301-222D prohibits expansion and enlargement of the non-conforming use. There has been no enlargement, no intensification, no physical expansion of the dwelling. The structure remains substantially identical in scope and intensity to its historic use. This is the same 5-bedroom, 1-bath home with detached garage, which has existed for decades. We are not seeking to increase occupancy, we are not seeking to add units, and we are not seeking to alter the footprint. Only continuation of what has always existed. In August 22, the town building inspector issued the letter of pre-existing use confirming continued use of the transient rental. That letter of pre-existing use resulted in dismissal of an enforcement proceeding in the town justice court for failing to obtain a rental permit. Neither the town attorney nor the court would dismiss a criminal violation for failing to obtain a rental permit unless the court believed and the attorney believed that a rental permit was required. Mr. Fisaro was advised that he did not need to do anything further and there was no rental permit requirement. 3 years later, without any hearing, appeal, or administrative review, the letter of pre-existing use was rescinded. We are here because the rescission of the letter of pre-existing use was arbitrary and without process. But even putting aside the board's authority is independent. The evidence before you establishes the non-conforming use by operation of law. Again, the rental permit process does not invalidate a pre-existing use. As a suggestion I made to my client was that this board, in granting our approval, and we would accept a condition that the applicant would get a rental permit. They have never objected to getting a rental permit. They would have cooperated and gotten a rental permit. But the rental permit process specifically prohibits, and the affidavit and the statement you make when you get one says, and you are not renting short-term rental. Putting yourself in that position would have put them in a fraudulent position had they applied for a rental permit, had they been instructed to do so. However, if the board grants our approval and conditions obtaining a rental permit, then we could attach on any rental permit application this board's decision and say, here, this is somewhat of a nuance or a caveat to the rental permit process. I think that in and of itself protects the community, protects the intention of the rental permit process to protect the public from terrible situations of people that don't maintain their property and create hazards to the community. In our case, the Fasaros have been diligent. In '22, they got a full inspection. They got a pre-CO inspection, electrical inspection, and to the extent that all of the agencies reviewed the condition of the property in '22 and even to today, the property is well maintained with proper smoke detectors, proper monoxide inspectors. They are a good owner of the property. They are really not what the rental law was intended to apply to. I would also point out that in 2022, it's my belief that they did not believe he needed a rental permit, is that the rental permit process excludes B&Bs, motels, hotels, and such. So when the building department believed that he had a pre-existing short-term rental, it made sense that he wouldn't need to go get a rental permit because he was being treated more as a commercial, I don't want to say hotel motel, but in that, or a B&B, it was kind of a hybrid. So without a clear indication one way or another, they told him you didn't need anything further. The code, the rental law just doesn't provide for hybrids. I think there's always a chance, or no, always an ability to customize something based on the circumstances. So in conclusion, for more than 60 years, this property has operated in the same manner. The town changed the law. The owners did not change their use. The Constitution protects vested property rights. New York law protects pre-existing non-conforming uses. And the Riverhead Town Code codifies those protections. For those reasons, we respectfully request that the board issue a determination confirming that 47 Bayside Avenue is entitled to the continued use as a lawful pre-existing non-conforming single-family dwelling with transient rental use under 301-222. Thank you.
Ms. Moore, I can presume that this last thing that you entered tonight, the thing with the years and all, is that the days that it was rented?
So there, you have,
That's a yes or no question, is that?
No, I don't know what you're showing. Is that what you have in front of me? I can't see.
Yeah,
Because
thank
of my
you.
different
By the way,
glasses.
your concept of a moment and mine disagree.
Well, yeah, forgive me. Thank you. Yes. This document is a quick rundown of all of the
Thank you.
the renters.
Thank you.
Thank you. I
Attorney Moore,
appreciate your patience.
can I ask you a question?
Yes.
I was looking through that, and most of the stays that are in here are less than 30 days.
Yes.
And you mentioned before hotels and bed and breakfast. Do your clients file Suffolk County hotel tax?
Yes, they do.
Do you have evidence of that?
I think did we provide it already? Yes,
Yeah,
it's in your packet. Yes.
All right, thank you.
Yes.
Good night, thank you. Well, we have to adjourn this to reserve decision, I presume, right?
Well, Your Honor, sorry, that's your old title. We would request just a 1-month adjournment to give us an opportunity to review and see if there's anything else that my clients want to do,
What's the
if that's
attorney's- what's our
acceptable.
attorney's pleasure?
So, the original hearing date was when, Heather?
I have to look, it was a long time ago, but this was the second adjournment.
This is only the second,
Yeah, but, so, from the original hearing, the zoning board did grant 2 long adjournments. The zoning board has accepted every submission that you've wanted to make. You, obviously, the issue with respect to the determination that brought you here, that was back in October.
yes, we filed within 30 days of that determination.
Right.
How
So
much time do you suggest?
this has been going on for a long time.
Yeah,
And-
no,
and
I understand.
As applicant, you have had a extended period of time to present or gather any information that you wanted the zoning board to consider. I mean, so Heather, what was the original date? Can you give me the history?
I can attest to the record being voluminous.
For lack of a better word, it's robust.
Robust. Well, it's proof. So
Well,
I,
but the thing is, I don't think you're gonna add. What else can you add that we don't, what else are you gonna add that we already don't have? How about 2 weeks?
it's a continuation.
2 weeks?
2 weeks
2 weeks.
is acceptable?
27th.
27, so moved.
That's fine.
26.
26 is your next meeting?
Yes, February 26th.
So
That's
moved.
fine. That's fine. Thank you.
I second.
Okay, and it was, I think it was October
All in
23rd
favor? Did you vote?
was the original.
There was a motion and a second.
Okay, Mr. Barnes.
I think I so moved,
Aye.
and it was seconded.
Four.
I second.
Aye.
Mr. Zawiski.
Aye.
Gazelle.
Aye.
And I vote aye. So you've been moved to February 26th.
Thank you very much. I'll assume, if it's all right, if we have nothing further, we'll just send a note or a letter saying, yes, please close the hearing, and then you can act, if that's acceptable to the board.
Yeah.
Thank you. We don't want to have to appear and take your time. Thank you.
Okay.
Moving right along, appeal number 2025-044, Robert Crinian, 9 Holly Tree Lane, Jamesport, Suffolk County Tax Map number 600-69-3-12, Residence A40 zoning, proposed in-ground pool. Applicant requests variances and/or relief from Town Code Chapter 301-15A1A, where accessory structures are not permitted in the front yard. Chapter 301-15A1B, where proposed accessory side yard setback from a side street is 10 feet, where minimum required is 50 feet, and Chapter 301-11, where proposed impervious surface coverage is 33%, where maximum allowed is 15%.
You attorney?
Me? No.
Okay, raise your right hand. I do solemnly swear to tell the truth, the whole truth, and nothing but the truth. So
I do.
help you God. State your name
I
and
do, Robert
address.
Crinian. How do you spell it?
CRINNION.
And in this weather, you hear about a pool?
Excuse me?
In this weather, you hear about a pool, right?
Yeah. From my wife.
And I can confirm we received the receipt of certified mailings and the affidavit of posting.
Right ahead.
Excuse me?
Go ahead.
Present your case.
Yeah, we're looking to put a built-in pool and a patio around it. I have a corner plot, so the biggest area to put it in is on the Jamesport, the High Tree Lane and Peconic Bay Boulevard side. It's a big open area there. We have right now a wood deck that we're gonna take down, patio in, put a pool in, and yeah, that's it.
What kind of fencing are you going to have around it?
Steel fencing, yeah.
How are you going to address the front of it with the hedges and all that out there?
I'm gonna landscape it really good. I want it closed in nice and,
You're going to landscape it, right?
well, my landscaper is, yeah, yes.
So would you have any objection with a recommendation that that landscape plan be approved by planning department, planning staff?
Sure.
Mr. Crinian, is the lot to the west?
It's been abandoned. We've been there for 5 years. Retired Riverhead cop lives next to me, Tom,
Lassard.
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 yes. He's been trying to contact the people for,
Okay, so that little lot in between there is,
Yeah,
yeah, it's a narrow lot, right?
it's a narrow lot, but it goes the
Way
whole
back.
depth of the property.
Okay.
Yeah, they actually, there's a camper on it, there's an old boat, and like a kid's plastic toy, that's, you know.
And would you plan on, the hedge that's there, is that on your property?
What's that?
The hedge that's on Peconic Bay Boulevard?
That's actually, that's right where the property ends.
So, but is that your hedge, or is that,
I believe that the people prior to me put it up, but I think it's your property.
so would you end up, so if it got knocked down, you basically have a pool that was right on Peconic Bay Boulevard, and everyone
Yeah,
looking at you?
but we're gonna keep those hedges. It's, the height of the pool height is gonna be about 2 foot higher.
Mm-hmm.
So it's gonna, sort of come up, and along that side, we're gonna put an extra set of hedges.
Okay,
And then along the abandoned lot side, because we don't really like to see it, we're gonna put hedges on that side to, minimize the sight of seeing the abandoned lot.
okay. And then what kind of fence are you putting around the pool? Is it gonna be a solid fence, or is
It's
it?
gonna be one of those, metal fences with the top rail and metal, and then,
Okay.
you know, like every, 4 inches, I think.
Yeah, 4
Yeah.
inches is
4
code.
inches, go with another, you know, I guess they call it post, a new pole, you know.
But like, in other words, not see-through.
Well, you'll be
You
able to
would be
see
able to see
through
through
it,
Yes, you would.
It will be?
but
Okay.
it won't, because we have such a beautiful view.
Yep.
I'd like to sit in the pool and still see, you know, my wife likes to look at when the sun sets, we actually get a great, coming right across the aisle, we get the other side of the water, gets a great view, you know, the oranges and purples and everything.
So you're gonna screen it from those sides? No, that all makes sense. Just, you were talking about the 4, just having learned the lesson the hard time. It's 4 in between, but at the bottom it's 2 on your fencing.
Okay.
It's 2 inches on the bottom,
And it
Okay.
can't be climbable.
Right, okay.
so.
Well, I think that the pool guy's good, but it's Arthur Edwards, who's a big pool.
They've done plenty of them, they know.
Yeah, so he's gonna know what, you know.
Heather, did we receive any correspondence on this application?
No, we didn't. Did you receive any, like, letters from the neighbors or anything? No.
Is anybody online?
We have people online. There's no one with their hand raised. If anyone wants to speak on this appeal, please raise your hand. Nope, no takers.
Okay. I have it. Mr. Chairman, with respect to appeal number 2025-044, I move that the appeal of Susan and Robert Crinian, 9 Holy Tree Lane, Jamesport, STM number 600-69-3-12, Residence A40, RA40 zoning, for variances and/or relief from Town Code Chapter 301-15A 1A, where accessory structures are not permitted in the front yard, Chapter 301-15A 1B, where proposed accessory side yard setback from a side street is 10 feet, where minimum required is 50 feet, and Chapter 301-11, where proposed impervious surface coverage is 33%, where maximum allowed is 15%, be granted, subject to planting plan approved by the Planning Department in accordance with the applications and sketches with amendments thereto, if any, as filed with the building inspector.
Second.
Okay, Mr. Barnes,
Aye.
Mr. Porsche,
Aye.
Mr. Zaweski.
Aye.
Ms. Gazillo. Aye. And I vote aye. So variance has been granted.
So
Good
I
luck.
have to get the planting plan done.
Yeah, or even
Plan.
if you had a list of species and, size that you're gonna plant, you can submit it to me and I'll take a look at it.
Okay.
Natives are preferred.
Right.
I know that deer are an issue all over Riverhead, so if you need suggestions, I can suggest some deer tolerant species if you need them.
So I let that to you, and then I get the permit?
You'll get a written determination, which you can bring to the building department, and then, it'll be an approval, whatever your plan is or the list of plants. planning will okay it, and then you can proceed with building.
Great.
All right.
Thank you.
Welcome.
That's expensive.
Okay. Last appeal of the night, appeal number 2026-001, 1175 West Main LLC, 1175 West Main Street, Riverhead, Suffolk County Tax Map Number 600-125-2-25.2, Riverfront Corridor Zoning for a special exception pursuant to Town Code Chapter 301-222B. The Zoning Board of Appeals may approve a special exception to allow the change from one nonconforming use to another. Applicant requests conversion of western portion of building from pre-existing nonconforming spa restaurant to showroom, storage, and offices for heating and air conditioning business, not a permitted use within the Riverfront Corridor Zoning Use District.
Mr.
Good
Cuddy,
evening. Charles
welcome.
Cuddy for the applicant. I have an office at 445 Griffin Avenue, Riverhead. With me tonight are two principals of the company, Chris Geiger, Frank Stresser, and also the architect. So they're all here to hopefully get this approved. But basically what they have is they have a change of zone situation because, when I say change of zone, change of non-conforming use. There was a fish market, which probably you're familiar with. Boy One was there for years. It also became a partial restaurant. They want to put in that same site, not changing the site at all as far as the building is concerned, a heating and air conditioning business. They do a couple of things. They sell the heating and air conditioning. They would have in front of the building a showroom. They would have an office in it. They would have a storeroom in it. They run a similar type business in the West Hampton area, and they want to not leave that business, but they want to come here and expand their business. This is certainly a less intense use than was there. It doesn't use the nighttime area for the restaurant. It closes at that time. It doesn't really impact the neighbors the way the other restaurant would. I think it's much less of a nonconformity. The reason it's nonconforming is because it's Riverfront Corridor. And I'd just like to hand up, if I may, a pictorial representation of that area. I think there's 7 of them there.
Thank you.
That's designed just to show that there are a number of different uses there, similar type business uses. And that whole area, which is sort of a blue-purple color, is the Riverfront Corridor. The one across the street is the Peconic River Corridor, Community Corridor. This is also across from the pet site, which is the pet hospital. So all of the things around them are basically business. There are a few dwellings. There are dwellings next to them. The people in those dwellings have been contacted, and they have consented to what they want to do, which I say is much less than the restaurant that was here. I know that under the code, any special exception must go through a whole process, which is required by Chapter 105-8. And that says that there are 4 determination factors. There are 13 conditions. I don't think you want me to read all of them to you. I'll go through some of them, but I have made them in writing so you can take a look at them. So just to review this, there are 4 principal determinations that the board must make. And those are the first 4 on the first page, that the use will not prevent the orderly and reasonable use of adjacent properties or properties in the surrounding area or impair the value thereof. I think that this use and the sale and the installation and repair of heating and air conditioning equipment is much less intense than the fish market restaurant operation, and will have much less impact on the neighbors. Number two is that the use will not prevent the orderly and reasonable use of permitted or legally established uses in the district wherein the proposed use is to be located, or permitted or legally established uses in the adjacent districts. And what I said was that the use will not have any negative impact on the neighbors, as the customers come by appointment, by the way, at this site. They don't just come in. They come only after they're calling and set up an appointment. So the hours are pretty limited as to the number of people that are going to be there. So the effect on the residences would really be negligible. The third item is that the safety, health, and welfare, the comfort and convenience of the order of the town will not be adversely affected by the proposed use in that location. And I think this is a safe business. It's not adversely impacting the welfare or the health of the community at all. And I think similarly, when you get to number 4, it says the use will be in harmony and promote the general purposes and intent of Chapter 301. And Chapter 301 is the basic zoning provision, and that it certainly encourages the appropriate use of land and promotes the health, safety, and welfare of the community. And I think that this type of use at that site, based on the other uses that are there, certainly is appropriate. Doesn't impact, as I say, anybody, and I would think that the town would be happy to have the use changed. So I, under the circumstances, would ask that you approve it, and I would also note that there had been a decision similar to what we're asking for, but it was many years ago in 2016, but it allowed the exact type of use that we're talking about here, a change of use. Certainly, if there are any questions, we'd be happy to.
Mr. Kennedy, you indicated storage. Will there be any outdoor storage?
There may be some on what I think are lean-tos that are already there, but basically they're going to use the inside for storage. They're going to use it for 3 things. They're going to use it for showroom, for an office, and for storage.
But there won't be much outdoor storage.
No.
So I was intrigued with the appointment portion. At least initially, when I look at heating and cooling, I would expect you'd have contractors coming in, things like that. Is this really just operating more as a showroom for the most part, and you have customers coming in?
But the customers come only by appointment. In other words, they have to call in, they set up appointments for them to come in.
So all of the retail sales are by appointment?
Yes, yes.
Okay. So in other words, if I was looking for a part,
We wouldn't sell anything. We wouldn't sell a party.
If you're going to speak, can you come up to the podium,
You
please?
have to, you got to,
so looking at the current layout of the property, it almost looks like there's roads running through it.
Driveways.
I have a photograph.
We'll get, sir, we'll swear you in. But just solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name and your address.
Strasser.
First name,
Frank Strasser,
okay?
1175 West Main Street.
Very good, thank you.
Justin, are we able to get the camera on the ceiling to zoom into the picture Anne-Marie put up? Thank you.
Okay.
So that's the adjacent property. The Osmonds owned all those plots of land there, so they own the 2, possibly 3 to the right, the seafood restaurant, the property to the left, and then the back plot that goes up to the river. So they utilize that whole property where they would drive through and access the other properties through 1175. So those roads that come across the property, they're right on the edge. They're not really using them. It's like split where the road is halfway on the property line, halfway on their property line.
Is that a mobile home on there also, that white line?
Is there a trailer on there now?
Okay. having a hard time seeing that. The white line there, I'm sorry.
What you-
The white
It's
rectangular,
Yeah, take a look at this one. It's the same thing.
So that was a tractor trailer that Bowie One used for storage. That was taken out of there already.
it's gone.
Yes.
Okay, thank you.
And on the survey you submitted on the, I guess it's the south border, there's a, looks like something identified as a lean-to that's right on the, looks like it's right on the border.
Right on the property line.
16 foot by something.
They were storage sheds for firewood, so that they were just they're like dilapidated fence storage spaces for old. So they had a fire wood burning stove in the place. So I guess or a fire pit outside. So they stored firewood there. It was they called them lean-tos on the survey.
So is your plan to remove them?
We weren't planning to do anything with them. If we have to, we absolutely can.
So, Mr. Cuddy, are there easements on this property for these roadways and means of ingress and egress?
Not that I'm aware of, no. I think they just used it because it was convenient.
Right. Well, the question is that the continued plan?
Not on your part of it. Not certainly on their part of it, if we can tell them to move it over, because we don't
Right.
want it, we really don't want it on our property.
Well, this is going to require site plan process, correct?
Yes,
So I'm sure during that process, that will have to be addressed.
yes, and we don't have a problem doing that.
Then just one other question, where the, I guess the dining was, where there's the red masonry there. Is there any use of that, or is that just going to more or less just be there?
We're probably gonna put grass there, green space, whatever they allow us to do. If we need to put grass there, we'll put grass there. If they want flowers, we'll put flowers. We're not planning to use it for anything other than
Building looks
just
good.
aesthetics from the front.
The work that you've done on the building, it looks good.
Thank you.
And then lastly,
May I ask a question, Mr. Chairman?
Sure.
Is in part the building currently being used by a personal health spa? Am I looking at the right application?
No, it's not. It's not currently being used as a spa. It was.
But it was.
It had been at one time, yes.
Okay, so do you intend to use the whole building for your operation?
Yes,
And is there anybody else going to be renting on the property other than yourself and ownership of, you own the building, correct, and the property?
No, nobody will be renting. We'll occupy the whole space.
The whole space and the whole real estate?
Correct.
The whole parcel?
yes.
Correct.
Okay. All right, thank you.
Yeah, I think when they initially made the zoning board application, because they're phasing the construction, they had only pointed to a portion of the building, but because the special exception would essentially run with the parcel, it's important to identify
Okay.
everything that they're gonna be using it for, so it'll
That-
apply to
that
the whole
makes
building
sense.
and parcel. And then I did just wanna note that we received, a letter in support for the application from the property owner, ZBA Holdings Incorporated, 1159 West Main Street. And then we received additional letters in support. I believe there are 4 of them in here from neighboring property owners at 1167 West Main Street, 1205 West Main Street, 1165 West Main Street, and then 1191 West Main Street. Was that everything?
Nobody else wish to be heard?
Anybody waiting on Zoom there, Heather?
We do have one person on Zoom. If you want to speak on this matter, please raise your hand.
Nope.
Any acknowledgement? No acknowledgement? No acknowledgement?
No.
We don't have anything else, do we?
No.
Okay, who's got it?
Reserve. Oh, Heather, you gotta give me the dates. So, can I read it?
Yes, absolutely.
Heather, what's the, February 26th?
26 is the next date.
So the, motion for the zoning board is to close the hearing, mark it for reserved decision, February 26th.
So moved.
Second.
Okay, Mr. Barnes,
Aye.
Mr. Porsche,
Aye.
Mrs. Zawiski.
Aye.
Mr. Gazillo,
Aye.
and I vote aye, so variance has been granted. Good luck.
Thank you.
Hey.
Welcome.
Thank you.
Great. We didn't have any minutes from the last meeting, so they'll go on for the next meeting when we get them.
Okay.
So the next meeting date is February 26th of 2026.
So moved.
And do we have a motion to adjourn?
So moved.
All in favor?
Aye.
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 Aye.